The judge says all charges are dismissed in Alec Baldwin's case from the shooting on the set of Rust. We've got some thoughts. Stay tuned. This is attorney Andy Marcantel and attorney Brittany Huttner. We're attorneys from the Attorneys for Freedom law firm here today to discuss a pretty interesting, high-profile ruling. How you doing, Brittany?
Good. How are you doing, Andy?
Hey, it's cool to do a podcast with you finally.
Yeah, this is super exciting. Usually it's just me, Emma, and Rachel.
Yeah, the reason why I wanted to do this podcast with you is because you had previously talked about this case in some of its earlier stages. What parts did you comment on again?
Yeah, so it was actually before the trial even was set. It was just when the charges were rebrought against Alec Baldwin. So we actually did a video when Gutierrez Reed was found guilty from the jury before.
That's the armor, right?
Yes, before Alec Baldwin's case went to trial. So this is a huge update.
Yeah, definitely. And what's another interesting thing is you and I haven't really talked much about this particular ruling in Alec Baldwin's case. And we did that intentionally because frankly, I don't really know how I feel about it. I have some thoughts about it, but I'm not sure where I'm going to ultimately conclude today. But I do have some strong thoughts about it. I don't know what your opinions are about it, other than maybe a few words that we said to each other before the filming of this podcast, which I like. This will be exciting. We can talk it out and figure out what our legal opinions are, what our moral opinions are. On this particular case in real time for our viewers. So should be an interesting episode. We don't exactly know what you're going to say.
I have no idea what's going to come out of my mouth, right?
Yeah. Also, just a side note, I don't care about Alec Baldwin strongly one way or the other. As an actor, as a political activist, as a human being, frankly, I don't have a strong opinion either way. I thought he was funny as the cop in The Departed. And I thought it was hilarious how the creators of South Park mocked him mercilessly in Team America World Police. Other than that, I don't watch Saturday Night Live. I'm not familiar with a lot more of his acting other than that. So my opinions of Alec Baldwin are not going to be a factor here.
Awesome. Yeah, I actually don't really know much about Alec
Baldwin.
Baldwin.
Are you part of the Alec Baldwin fan club?
No, unfortunately I'm not. So if you are, welcome. I'm happy that you're joining us.
President and armorer of the Alec Baldwin fan club. Not a job you want.
No, not a job that I would not want to be an armorer after this case. This is crazy.
So the ruling from the judge in this case, and that is Judge Sommer in the case, has thrown out the case. And
with prejudice.
With prejudice. Yeah, you want to explain what that means real quick?
Yeah, that means that there cannot be any more charges brought. So before the procedure, kind of to talk about the procedural history, was he was originally charged, Alec Baldwin was originally charged in 2023. The state then dismissed the case because they did want to investigate more, and then they rebrought those charges in January of 2024 this year. So they can't do that again. It's dismissed, it's gone, done forever. He gets to go home and not have to worry about this in the future. Yeah,
and that's it's kind of a rare thing for the judge to dismiss something with prejudice. Most dismissals we see as criminal defense attorneys are without prejudice. And without prejudice simply means that they can file again within the statute of limitations or seek a new indictment. Oftentimes, if not most of the time, when you get a dismissal without prejudice, it's effectively the case is over because rarely is there new evidence or reason for the prosecutor to try again. But it does happen. But the judge in this case says, nope, the state cannot bring this one again, and I am dismissing it with prejudice. So interestingly, this case has kind of become an interest of the Second Amendment community. And we speak a lot about gun cases, self-defense cases, negligent shooting cases, things of this nature. And so the Second Amendment community, I presume, got interested in the case because it involved guns and it involved the alleged negligent mishandling of a firearm on a movie set. But interestingly, the ruling in this case dismissing it has nothing to do with the merits of the case. And in fact, the judge is saying, I am finding that this case needs to be thrown out forever because the prosecutor mishandled or concealed important evidence and threw it out for that reason.
Yeah, and that's not at all common. Prosecutors understand that the ethics rules require them to disclose all evidence that could be, pressing or important to the case. So we don't see this often. At least I haven't. And so to see the prosecutor do this, maybe good faith, bad faith, don't know, and then for a judge to subsequently dismiss it is a huge deal, especially ethically. Yeah,
very good point, too, because there are other remedies that a judge has when they find that the state has concealed certain pieces of evidence. One of the remedies, for example, might be all right, I'm finding that the prosecutor mishandled or concealed this evidence. Therefore, as a punishment, I'm going to order the state not to talk about that particular piece of evidence during the trial in front of the jury. We might call this suppression of evidence. And that's much more commonly used remedy by the court to fix these types of problems than a complete and outright dismissal of all the charges. So in other words, the judge found that what the state did in this case was particularly egregious. And Brittany, why don't you walk us through what the state did in this case?
From what I have researched, it sounds like obviously Gutierrez Reed's trial concluded. She was sentenced. After that trial, there was an individual who gave the Santa Fe Police Department a box of ammunition, saying, hey, this could have came from the set of Rust. Now, after that, the police did give that to the prosecutor, and the prosecutor filed that under a different case number. Because of that, Baldwin's defense counsel had no idea that these bullets reemerged or anything about that. It then came out in trial. And then they said, whoa, hold on. I haven't seen that before. What's that? And
not only filed it under a different case number, didn't tell the defense team about it.
No. And that's kind of where my eyebrow raises, right, is that I don't think I've made the determination before this conversation if that evidence was material to the defense. But I find it interesting that why did they file it under a different case number?
So suspicious.
It's so suspicious, right, that I'm like, hey, I don't know all the facts, right? The trial only happened, for 2 days, so not all the evidence came out. Maybe I'm missing something of why this is so material, but I feel like it has to be if the state is actively trying not to disclose it.
Well, that's not going to be enough for a dismissal with prejudice. So we have gut reactions as criminal defense attorneys. We fight the state every day. We expect the state to play fair. There is a guttural response when you hear that the state is intentionally or in bad faith hiding, suppressing, concealing evidence in some way, because it kind of feels like the state's trying to frame this person, right? That should be the gut reaction when you hear conduct like this from the state. But that ain't enough under the standards of Brady, and it's Brady v. Maryland is the case that was referenced by the judge in this case as justification for tossing the charges. Just that we have a gut reaction that it really seems that they should have given it over ain't going to be enough. You got to show, as you referenced, you got to show that this evidence that was concealed was material to the actual case. So what does material mean, Britt?
Material means that if it was disclosed, it would have been more likely than not affect the actual case.
That's right. Like the outcome would have been affected in some way if this piece of evidence was known. And so the question then arises, how is this evidence material? And putting aside my defense attorney advocate hat for a moment and just looking at the reading of Brady v. Maryland, one, you got to show that the prosecutor did the bad thing by hiding it, concealing it, not giving it over in good faith. But two, you got to connect the dots by saying, and the thing that they hid or concealed was actually material to the case. It would have affected the outcome of the case in some way. Now, Alec Baldwin was being charged with involuntary manslaughter, which there's two different theories under New Mexico law of how the state could have proved that. One, they could have shown that he committed a misdemeanor, essentially, of negligently mishandling a firearm and a death occurred. That would have made it a felony, involuntary manslaughter. The other way that they could have shown it is, and to just quote the statute here, he handled the firearm without due caution or circumspection, an act of total disregard or indifference for the safety of others, and a death was reasonably foreseeable because of the way that he was recklessly handling it, and a death occurred. So that's another theory of involuntary manslaughter. So how is where these bullets came from, and who sourced the bullets, and whether these bullets that were turned over by this guy, even though the guy was saying, I believe that these match the bullets from the set of Rust, how is that material in any way, shape, or form?
I don't know, and that's what I'm struggling with. I guess I'm struggling because I don't see why that's relevant to his conduct, right? We know that there was a live bullet. Somebody lost their life and another person was injured. That's not the question. The question is, was he negligent, right? Or did his actions meet the standard involved? Now, we know that there were live bullets. We know that there was live ammunition. Somehow it got on set. And he actually says that, he has no idea how it got on set. And he actually says he didn't pull the trigger. He cocked the hammer but didn't pull the trigger. And he's been saying that the entire time. So I don't understand why having these, 6, 7, 8 other bullets that could have been on scene is relevant to his defense.
Right.
I don't see it.
And Special Prosecutor Morrissey, who was the prosecutor on the case, testified and said,
That's interesting.
That's another odd thing about this case, because there was a hearing conducted about why this stuff didn't get disclosed to the defense. Special Prosecutor Morrissey swore herself in and took the stand to testify that in her opinion, when she heard about these bullets being turned in, she just made a determination that they weren't material. Simple as that. I saw this. I heard about it. The guy said that these bullets matched the ones found on the set of Rust, and I determined this has nothing to do with whether or not Mr. Baldwin allegedly negligently mishandled the firearm. This has nothing to do with involuntary manslaughter. And so I'm unilaterally making the decision that they are not material. And so I'm not going to disclose them. And in fact, I think they're so immaterial that I'm not even going to put them under Baldwin's case number. I'm going to put them under a different case number entirely.
And she did say that they didn't, when she looked at them or inspected them, she didn't think that they looked like the same ammunition on the Rust, like in the evidence under the case number for Rust. So that's also why she also thought that it wasn't relevant. But when the defense lawyers inspected them, they found that some had brass casings with the Starline brass logo, silver nickel primers, just like the 6 live rounds found on the set of Rust. And then others looked like the dummy rounds that were also taken to evidence. So they did kind of dispute whether or not they actually looked like the ones on set. But that was another reason why she said, well, I didn't even think they were relevant, because they didn't even look like the ones that were actually on set.
Yeah. And so the people who are in favor of this dismissal, the judge's ruling to dismiss the case, make a very, very valid point that it is dangerous to allow a prosecutor to simply unilaterally decide if something is relevant or irrelevant. In fact, this is the spirit of the Brady decision. It's saying that, prosecutors can't just unilaterally make a decision of the relevance of this. We got to give the defense, we got to afford them due process. We got to allow their attorneys to take a look at it and make an assessment for themselves. Lo and behold, as it turns out, defense attorneys are looking for different things in trying to defend a client than a prosecutor is looking for in trying to prosecute their client. And so we might see things of high, very high relevance that a prosecutor simply doesn't see or is dismissing. Our brains are wired to look for different things. But on the flip side of that, as it turns out, prosecutors regularly unilaterally decide if something is relevant, irrelevant, or material. And they make these unilateral determinations all the time on what should go in the discovery, right? Prosecutors don't seize every single thing on a crime scene as relevant, and prosecutors don't have to give over every single fact in a case under the guise that it might be relevant. I have if I'm working on a DUI case and the prosecutor doesn't turn over a piece of gum that was found on the sidewalk near the traffic stop, I'm not going to complain about that as being, they unilaterally decided that the piece of gum was irrelevant. That's dangerous for due process, and they should have turned it over.
Yeah, and we've seen this too in cases where there's a witness, right? They may not, I know you were talking about prosecutors, but even detectives and investigators and police officers, they might not, like you said, grab something at the scene, right? If there's a video that could be beneficial to us, we would have to request that, because if there is a witness, they might not do that on their own. I just think it's interesting though, because in this case, clearly the bullets that were potentially at the scene is different than a piece of gum by a DUI traffic stop, right? So I think that's just, I would hope that prosecutors err on the side of caution and collect the evidence and disclose it.
They might have the same amount of relevance. The bullets that might match the ones on the scene might have the same amount of relevance to proving beyond a reasonable doubt an involuntary manslaughter charge against Alec Baldwin that a piece of gum on the sidewalk has to my hypothetical DUI client. But one sure does hit you in the gut differently than the other, right?
Yeah.
Like, it's interesting because even the people who I am seeing critiquing this judge and the ruling, saying, yeah, it's true, the prosecutor probably should have erred on the side of disclosing that and letting the defense know and everything, but it's not relevant, it's not material and everything. Even they are conceding that something about it smacks you in a way that something about it makes you say, that prosecutor probably should have turned that information over to the defense.
And it's also a difference of, whether or not they get the evidence and disclose it, right? So in this case, the evidence was handed to them figuratively and literally on a silver platter, right? And they decided to accept that evidence, right? So it's not like they were like, oh, no, that's okay. I looked at it, doesn't look like it, right? They accepted the potential evidence and then also filed it under a different case number. And, other cases, maybe they didn't collect the evidence or maybe they turned it away or didn't think that it was relevant. But I think it's interesting that they accepted the evidence and then filed it, but just under a different case number. Then why did you do that if you didn't think it was material? Like, you should have just been like, oh, sorry, the trial was already concluded for Gutierrez Reed. Sorry, too late even, right? It's weird that they took it from the individual.
Who, by the way, just announced, no surprise here, through her attorney, I think yesterday, that because of this ruling in Alec Baldwin's case, they're immediately filing a special appeal. They're asking for an immediate release from custody. And I would too if I was Gutierrez Reed's lawyer, because this evidence wasn't disclosed to her defense team.
And I think it's also interesting that the evidence was actually disclosed after her trial.
Right.
I mean, the incident happened years ago in end of 2021. And the fact that all of a sudden, super weird that after her trial completed, after she was sentenced to 18 months, then this evidence just miraculously appears and that the state has it for Baldwin's case.
Yeah.
Just weird.
Yeah, so when you listen to the judge's ruling, and I listened to it a few times, and what I was really listening for, because the judge is going through the elements of Brady. Like, here's what Brady requires, here's what the state did wrong, here's the materiality of the evidence, and here is the remedy that I'm going to give as the judge in this case, ultimately dismissing it. I was really on the edge of my seat for the discussion of alleged materiality of these rounds, right? I couldn't wait to hear why the defense met their burden of showing that these things were material in any way, shape, or form. And the judge more or less just kind of reads over that part. The judge uses conclusory language that, yes, these things were definitely material. They were disclosed late. The fundamental fairness of the proceedings have been impacted by the late disclosure. Okay, but the standard of Brady is that they have to actually be material.
Yes, and she said there's just no way for the court to right this wrong, and that's how she concluded. She also said that jeopardy is attached, so she did mention that. There was a juror interview, though, with New York Times.
Yeah, I saw that.
And they commented on, the substance of the case. I thought that was interesting.
Yeah, and I understand several jurors probably would have been leaning towards dismissing the charges anyway had it actually gotten to the guilt phase. And if it was sent to the jury, there were several jurors that were like, it's ridiculous that he was charged with this. It was clearly an accident. Doesn't rise to the level of involuntary manslaughter, which requires some sort of negligence. So who knows what would have happened. But as far as this ruling goes, I'm happy that the ruling went this way. And the reason is because I think as a society, we generally need to encourage prosecutors to err on the side of disclosure. We want to discourage prosecutors from making unilateral opinions about potentially probably relevant evidence. This definitely smacks differently than the piece of gum on the side of the road that's irrelevant to the DUI stop. This seems like it's something that should have at least been turned over to the defense. And as it turns out, the co-special prosecutor in the case resigned when this issue came up. There were two special prosecutors on the case.
Yeah.
And that prosecutor saw this evidentiary came up, and she said, yep, I agree with the defense. This clearly should have been disclosed, and so I want off of the case, and she resigned from the case. Really interesting that even she agreed that the state should have disclosed it.
Really interesting. Really interesting. I mean, first they took the stand, and then they got off the case and resigned. So you have very weird circumstances that we don't normally see. But I also think it's interesting, too, that the state even brought up the evidence in trial. The other argument could be, well, they weren't trying to, withhold it because they did bring it to their attention during trial, not when they're supposed to, but they did bring up this evidence. So I think that's kind of interesting too, is that they could have gotten away with it. In all honesty, I mean, it's sad to say, but they could have. And so it's interesting that they then brought up the evidence in the middle of trial, because then none of this would have happened.
Yeah, so think about this. And here's one reason you should be happy as an American that this ruling went the way that it did. Like, imagine if the standard was simply, okay, yes, we all acknowledge that the state did the bad thing, by hiding or concealing the evidence. But now that we found out about it, now that we caught the state doing that, which frankly was a stroke of luck in this case, could have not happened, but now that we caught the state in the act of concealing something, you know what? We've done a secondary analysis and we've determined it's not relevant. This seems to me, just from a public policy perspective, that it's going to encourage the state to hide as many things as they possibly can under the guise of, yeah, you know, we just kind of unilaterally decided it wasn't important to disclose to the defense.
And this happens all the time, I feel like, in our job, where sometimes the law isn't on your favor, but it should be, right? Or like, you know, there should be a more favorable outcome for our client because of a policy reason or something like that. And so the fact that I am not convinced that this case falls into the 3 requirements of Brady, but I am really happy with the outcome. And I think that was just, right? We talk about what is justice. That looks different in every case for everybody in every circumstance, right? Sometimes justice looks a little bit different than you think it would. But this, I like that it was, you know, although it's not super cut and dry into Brady, that it was a great outcome for the American people and for our justice system, right? I mean, I pride myself in working in the justice system, and I do think that our colleagues are honest. I do want to think that, right? And so the fact that this wrong was, you know, made right in this way was pretty awesome to see.
Yeah, I don't know. But then if I was a judge and I wanted to justify my opinion in ruling to dismiss this case under the rules of Brady, you could very strongly argue that just the fact that this happened was clearly exculpatory evidence, or just the fact that this happened affected the fundamental fairness and therefore meets materiality. And so to kind of go into that a little bit, there's a little bit of legalese, but just to kind of break this down. Let's say that I was representing Mr. Baldwin and I discovered before trial, so not at the moment, at the dramatic moment when it was found, but maybe before trial, I happened upon this information, or maybe even the state disclosed it later and didn't tell me about the evidence not being disclosed right away, but maybe then found out about it, or maybe I found out about it. But bottom line is I figure out that it happened, that this prosecutor didn't tell the defense at first and put it in a different case number and everything like that. That in itself is impeachment evidence. That in itself is saying, okay, so let me get this straight. The prosecutor in this case took steps to intentionally conceal evidence from Mr. Baldwin. I can maybe make the jury draw an implication from that the prosecutor was inherently biased or was trying to frame my client, or some sort of police wrongdoing or misconduct, that they're biased against my client. So just the fact that it happened in itself is impeachment evidence and arguably is material. So, of course, the judge didn't, it kind of left all that stuff unsaid. I don't know what the judge's argument was specifically that this stuff was material, but you know, come to think of it, Britt, it is material that this happened because it's important impeachment evidence. So I could very well justify my ruling like that.
This kind of reminds me of, you know, just the day-to-day of working on a case. Sometimes we send a preservation letter. Preservation letter says basically, hey, I think this could help in a defense, you know, with my client. Please save all video evidence from this date, this time, to this date, this time. If they don't, we can assume that that video would have been exculpatory for our client, and we actually get a jury instruction for that at trial if we do go to trial.
Good point. Yeah.
And so because of that, that's kind of the same thing with this. It's, you know, hey, preserve that because you don't know if that's going to be relevant or not, but just to have that for your defense, right? We want as much as we can get, and we, you know, so it's kind of that too.
It's got to be interesting too in a high-profile case like this. All right, this is a big movie star. And so you can imagine that the prosecutor's office is probably inundated with all kinds of different information. Of course, this is the only piece of information that ended up mattering for Mr. Baldwin in the end, and the only piece of information that the prosecution's office is currently kicking themselves that they didn't disclose. And by the way, just on a side note there, we can all agree, stupid blunder by the prosecution. Who just totally threw away the case on this stupid issue. But at any rate, I'm sure they're wishing right now that they had disclosed this probably innocuous piece of information to the defense. But I digress. Big movie star. And so probably a lot of people, I imagine, want their 5 minutes of fame. A lot of people have opinions on things. This guy, Mr. Teskey, who was the guy who went and gave it to law enforcement, wasn't even in New Mexico at the time. He was in Arizona, making the prosecutor Morrissey feel even more like this was irrelevant evidence. Who knows? They were probably hearing, the prosecutor's office was probably hearing things from all over the country saying, hey, this is relevant. In my opinion, this is relevant. We've worked on a bunch of high-profile cases here. We get lots of emails from random people, some people claiming that, oh, I have a secret piece of evidence that you guys need to be aware of, or I found a secret witness and everything like that. And while some do generate credible leads, to be fair, the vast majority of stuff you got to sift through because it's completely irrelevant, or bad actors, maybe even people acting in bad faith, or just people who want their 5 minutes in the spotlight. So that's an interesting question too, is how much stuff for this very high-profile case was the prosecutor receiving as purportedly relevant to the case?
Yeah, but I mean, it's interesting though, because they thought that it wasn't relevant, but then they still filed it under a different case number. I'm stuck on that part. It's that, like, although
it seems really suspicious.
It does, because, you know, they didn't, like, turn it down, right? Like we talked about earlier. It's not like they were like, oh, it's not relevant. It doesn't look like the ammunition. They said it doesn't look like the ammunition, but we're still going to take that. We're going to examine it, and we're going to just file it under a different case number. I just think it's weird that they even accepted it and then still filed it, or even accepted it at all in the beginning, right? Where, you know, when you're sifting through the things, you can say, okay, this isn't relevant, or this is just leading me down a wild goose chase. Where this, they accepted it, made that decision, and then also filed it. Why didn't they just not file it if they didn't think it was relevant? So I think that's just interesting. It's weird.
Yeah, that's a very, very good point, and I'm glad that you phrased it like that, because I can't even count the amount of time. It's innumerable times that I have had a prosecutor disclose something to me as evidence in the discovery with an email that says, hey, we just found this thing. Want to let you know I'm fulfilling my duties to disclose it, but it's probably irrelevant, and just letting you know, as a courtesy that I'm sending it to you. I can't count how many times that a prosecutor that I've worked with will err on the side of disclosure, right?
Yeah.
And this is just a matter of being a smart prosecutor, right? If you're not trying to be a corrupt, hiding things, especially in a high profile case like this, like with so much on the line and the nation's eyes on you. Stupid blunder by the prosecutor.
Yeah, especially because it's a high profile case, right? Usually you put the best of the best on these cases. And so I thought it was kind of shocking too that they didn't just say that it was an accident. I just accidentally filed it under the case number. Everybody makes mistakes, right? I think that would have been, almost better in their view than they actually intentionally filed it under a different case number.
You're really stuck on that case number thing,
I am,
Brett,
because,
and
it's
for good reason.
It's just interesting that they didn't just say it was a mistake. No, they stood by their decision that they purposely meant to not disclose this, right? It's not that it was a mistake. So I think that's kind of interesting too, is that they could have fallen on their sword, in a different way and said, I'm so sorry, this was an accident. I totally forgot. I went to disclose it at trial because I thought that you did already see it. That makes sense, right? That why would they also disclose it at trial if they didn't already think that they disclosed it? So I think that also kind of makes sense. So I'm confused why they didn't just accept that they maybe made a mistake.
Yeah, I mean, I hope that this case sends a very loud message to every single prosecutor in the country, which is err on the side of disclosure, even if it's to prevent national humiliation like this prosecutor in this case just suffered as a result of this stupid blunder. But more importantly, as Americans, we have a right to due process. The prosecutor, who's the government's agent, doesn't have a right to not disclose things because they unilaterally just decide, I've decided that it's not relevant, when it's of this type of a character, right? Within reason. And there's something, it's just one of those things where there's no case law really written on it that explains the feeling that you get when you hear that they didn't disclose this. You know it's something different than just some random thing that maybe wasn't disclosed, like an item on the set of Rust or something that somebody mailed them from New York saying, hey, this is relevant. If it's something like this, it just, you know it when you see it that it should have been disclosed. The prosecutor damn well should have known it. You're right that there might be a little bit filing under the different case number certainly makes it look suspicious. We care in our justice system about something called the appearance of justice. The appearance of justice is the idea that we want the public to have faith that the justice system is working and shady crap isn't happening behind the scenes. But what are your final thoughts? Do you have an opinion on whether this is a correct verdict, an incorrect verdict? And then separate question, are you happy about it?
Yeah, I totally have an opinion now. You after talking with this, where before I just came with vibes and some research. I do believe that this was the right decision. I think the argument of impeachability is super important and impeachment purposes. I do think that does make it material in and of itself. I do believe that if the judge did hear the first 2 days of trial too, and the fact that they did have this huge argument or discussion, I do believe that the evidence was material. I do. Even for that impeachment, purpose. I do think that was completely material. I do believe that they suppressed the evidence. They didn't say that it was a mistake. I do think they willingly did that, or knowingly did it, I should say. And I do think that it was probably favorable to Baldwin. And the judge was clear on Brady. She knew the 3 requirements, and she kind of talked through her findings and why she did it. So I do think that she saw enough to make it material. So I do think this is a good decision.
All right, fair enough. Yeah, this is a judge who, in my view, really wanted to dismiss the case because just objectively, the bullets themselves do not appear material to me to the charges that he was facing, period. I haven't even heard a convincing hypothetical by anybody sympathetic to Baldwin of how the bullets themselves could have been material. However, the fact that it happened, the fact that it was concealed, the fact that it was filed under a different case number, the fact that the defense was deprived of their ability to impeach the prosecuting agency and the officers for foul play is itself material. So if I was the judge, I would have probably had the same ruling with some explanation that that's the reason why I'm slapping the state. And so legally, I think that it can definitely be justified. I think, as I pointed out, I think there are arguments against it about this being legal simply if you don't go any further than are the bullets relevant in any way or material in any way to the charges. That being said, placing aside my legal analysis and talking about what I want as an American and what I want as somebody who is a part of the justice system is, we should be slapping the state as much as we possibly can when they don't err on the side of disclosure. That is the heart of the Brady decision. That is the heart of the precedent that comes from the United States Supreme Court. And prosecutors all over the country, I hope you learned a valuable lesson. Don't let this happen to you on a national stage in your charges against a movie star. But even on a local level for average people, we all get the same due process rights. We all get the same guarantees under the Constitution. And I hope any judge, if this was Alec Baldwin or anybody else, would toss out the case just as vigorously if there was a failure to disclose something that could even potentially be material. So that's my final feelings on it. I'm glad we talked that out.
Yeah, me too. And I think this case is interesting because there was a lot of opinion of whether or not he should even be charged in the first place. So the fact that the trial ended in favor of the defendant with not even the merits of the case, I think is kind of interesting because a lot of people didn't even think that he should be charged in the first place. So kind of a funny ending to an extensive nightmare for Alec Baldwin.
Yeah, I don't know if it's really over for him yet because while his criminal woes are now over, there is a pending civil suit, a related civil suit filed by the family. As people are probably aware, criminal law and civil law are different. Very oftentimes, alleged victims will not only be listed as a victim in the criminal case, and the state will prosecute that person, but also then the victim or the victim's family will file a civil suit asking for monetary damages. That is a whole separate proceeding and follows different rules, different standards of proof, everything like that than in the criminal. So Mr. Baldwin may not be out of the woods just yet. He's still got the pending civil case, and that one may get to the merits of the case under a much lower standard than the beyond a reasonable doubt standard that would be required to prove his guilt in the criminal case. They'll have to use a different standard called a preponderance of the evidence, which means that it's more likely than not. The jury needs to determine it's more likely than not that he handled the firearm negligently and caused her death. But we'll save that discussion maybe for another day. Maybe we'll do a follow-up video since we are now apparently the law firm's resident Alec Baldwin experts.
I'm honored.
I may not be a huge fan of Alec Baldwin, but I am a huge fan of analyzing the legal aspects of his cases. So let's keep it up.
Absolutely. This was fun.
Yeah, I had a good time talking about it. All right, guys, thank you very much for tuning in. Go and check out attorneysonretainer.us to learn all about our self-defense program and what it can do for you. Also, go check out attorneysforfreedom.com to learn all about our law firm and how we defend people at this law firm. If you like this video, be sure to leave us a like, leave a comment down below, subscribe, and share it with a friend. Until next time, this has been Attorney Andy Marcantel and Attorney Brittany Huttner. Peace.
Peace.